1985, preparing for trial. Tony asked his lawyer, Don Glover, to call 3 people as witnesses that would testify to the fact that on Friday, June 6, 1980, he was playing cards with them. Tony and Ozell Brown went every Friday night to the neighbor's home of Rosie and Albert King to play cards. The card games would last well after 2:30 a.m. Saturday morning. Glover made the request to subpoena the neighbors. Rosie King was called to testify at Tony's trial. Albert King and Ozell Brown were not called to testify. Tony felt that to establish his innocence, it was imperative to find Ozell and Albert to verify Rosie's trial testimony, that Tony was playing cards with them on the night that Gil was killed. This would prove Gaddy's story was not true. Finding Ozell and Albert is where Gene began. Mid-1995, Gene located Mr. and Mrs. King. Gene questioned Rosie and Albert at their new home about being subpoenaed to testify at Tony's trial and about the night of June 6, 1980. Gene was surprised to hear that Don Glover, Tony's lawyer, never told the Kings why they had been subpoenaed or what they were going to be asked. They knew that Tony was on trial, but had no idea what they would have to do with Gil's death that happened 5 years ago. At trial, Rosie told the jury about the regular neighborhood card game and that Tony came regularly. Rosie told Gene that she had felt a sense of disappointment. She knew there was more to it than what was being asked at trial. Only after Tony's trial did Rosie understand what the real question was that she should have been asked. It was her husband, Albert, who helped her figure it out. After the trial, Albert learned that Gil's death was reported to be on Friday, June 6, 1980, the night that a carnival was in town at the shopping center. The carnival was an unusual event in Dumas, and a number of the regular card players took their children to it rather than come to play cards. The Kings knew for certain that Tony was with them playing cards that night. Why didn't Tony's lawyer tell Rosie what night was even in question? Since Rosie testified at Tony's trial, only Albert was asked to give an affidavit about Tony being with them on the night that Gil was killed. The Kings had no idea why Albert was not called at Tony's trial. Albert said that he was there at the courthouse with Rosie and waiting his turn to be called to testify. Gene located Ozell Brown in San Antonio, Texas. Ozell told Gene,
"I heard that Tony had been arrested for this guy's murder. I did not believe that he could be found guilty. On the night that people said this guy was killed, Tony was with me and a number of other people playing cards over at the King's house. I remember this Friday night because there was a carnival in town and it was the talk of the town. A few of our card players didn't come to play that night because they went to the carnival. Tony and I were there, and knowing that Tony was with us, I never felt that he had anything to worry about. So I never thought much more about Tony's arrest. I really didn't think that Tony would even have to go to trial until hearing what you have just told me today."
This FBI report shows Ozell Brown acknowledging the fact that Tony Thrash was with her playing cards on the night that Gil was murdered. Ozell told Gene that she never received a subpoena from the court. Having heard the genuineness in what the Kings and Ozell Brown told her, it left no question in Gene's mind of Tony's innocence. And so, with affidavits in hand, Gene took them to several attorneys, but only to be told that the case was too old to mean anything after a conviction. Gene found that it is much easier for an innocent person to get convicted of a crime than it is for the system to allow an innocent person to gain their release after being wrongfully convicted. The attorneys told Tony and Gene that they need more than Albert and Ozell's affidavits to show Tony's innocence, and so Gene sought to find the direct source itself, Gaddy. While trying to find Gaddy, Gene begins to hear that Gaddy testified at Tony's trial pursuant to a hidden plea agreement with the prosecutor, Sam Pope. Tony had no knowledge of this agreement, because at trial the prosecutor had asked Gaddy if she had been promised anything in return for her testimony.
"No, I haven't."
Tony had always heard from authorities that Gaddy got out of prison because she had a terminal illness and given an early release. Gene scoured through the court records to see what could be found, what may or may not have been offered or given to Gaddy, and the records revealed. On September 18, 1985, Prosecutor Pope asked the court to give Gaddy immunity. On September 18, 1985, the court granted Gaddy use immunity. On September 19, 1985, Don Glover, Tony's lawyer, filed a supplemental motion for discovery, asking Sam Pope to tell whether any offers of immunity, leniency, sentence or charge concessions, or other inducements had been made to Gaddy. On September 24, 1985, almost a week after Gaddy had been granted immunity, Sam Pope answered,
"The state will request immunity. There are no other offers."
Without a doubt, the court records Gene found show that Gaddy had been granted use immunity, and that Prosecutor Pope said that there are no other offers. Yet there's still a question of just what is this immunity good for? Sam Pope asked Gaddy at trial whether she has immunity or not. Gaddy told the jury her immunity was for a video. Gaddy denies having immunity for her testimony in Tony's trial. These questions and answers were designed to make the jury believe that Gaddy's immunity only protected her from a videotape statement she gave from being used against her, while her trial testimony could be used against her. This was designed to make Tony and the jury believe that Gaddy was not promised nor given anything at all in return for her testimony at trial. The prosecutor also misled the jury about the court-ordered immunity, telling the jury in his closing argument that
"There was a grant of immunity in this case. It happened, and you need to know what it means. The exhibit is here. Basically, what it meant is that she's given me a prior sworn statement, and you heard her say something about the video. It was videotaped, and this gives her immunity from the use of that videotape against her in any further trial, and that's all it does. She didn't have immunity in here the other day. I don't want her to. That can be used against her."
At no time did Glover make any objections to what was being said by Gaddy or the prosecutor concerning this immunity, nor did Glover try to clarify for the jury whether or not Gaddy's immunity had a direct bearing on her trial testimony, and thus Tony took Sam Pope at his word also. Gene enrolled into a paralegal class to learn how to conduct legal research on a case. Gene asked her teacher just what did Gaddy's immunity mean from a legal standpoint. The teacher told Gene that Gaddy and the prosecutor both misrepresented Gaddy's immunity to the jury. The teacher explained that contrary to what the jury was told, Gaddy's immunity did protect her testimony in Tony's trial from being used against her. When Tony heard about this misrepresentation, Tony asked Gene to acquire whatever court record of Gaddy's that could be found. Tony reasoned that if they lied to the jury about Gaddy's immunity, what else might they have lied about? Venue was ruled to be held in Deshay County, where Tony and Gaddy's case was docketed. Jean went to the Deshay County Courthouse seeking copies of Gaddy's court records. While there, she saw that Gaddy had case numbers which were in different counties. Jean went to each one of these county courthouses to find records. It was in the Drew County Courthouse that Jean recognized that Gaddy had a plea and sentencing hearing held on November 12, 1985, 11 days after Tony's trial had ended. This was in 1998 when Jean went to Drew County, and outside of those present at Gaddy's hearing, this was the first time that anyone else had read or heard about Gaddy's plea hearing. Gaddy's plea and sentencing hearing had never been typed from the audio. Jean hired the court reporter to transcribe the audio tape and sent a typed copy to her. After reading these records, it was not hard for Tony and Jean to see why Sam Pope chose to hold Gaddy's plea and sentencing hearing in a different county. Here are pertinent parts of Gaddy's plea and sentencing hearing. The court.
Okay, how old are you, Miss Gaddy?
22.
And you understand that this is capital felony murder and that there are only 2 sentences that can be handed down under the practical charge. That's life without parole or death by execution.
Yes, sir.
All right, there is some arrangements that's been made relating to that.
Mr. Pope.
Yes, sir, Your Honor. We talked about the plea negotiations. I've got a recommended sentence, and the state's going to recommend that or move that this case be reduced from capital murder to murder in the first degree.
All right, murder in the first degree. I assume that you or your attorney has discussed some type of plea negotiation with the prosecuting attorney. Is that correct?
Yes, sir.
The court.
What do you understand that plea negotiation to be?
Right now, I believe it's 20 years. He's asking for 20 years, and that we are here now to see if we can negotiate.
Okay, all right. The prosecuting attorney has recommended 20 years or will recommend 20 years.
The court.
So this is definitely on the low side of the scale. The fact that she did assist the state in prosecution of a guilty party in here, and so the court will accept the recommendation of the state and will assess a sentence of 20 years, Ms. Gaddy.
Gaddy's charge reduction and 20-year sentence is an obvious reward given in return for her trial testimony against Tony. The record of Gaddy's plea and sentencing hearing was the first piece of substantial evidence that Tony and Jean uncovered that showed Sam Pope had not been completely forthright during discovery and that Gaddy committed perjury during trial when she denied being promised nor given any form of a reward in return for her testimony against Tony. We now know that Gaddy committed perjury with the help of the state. Years ago, the Arkansas Supreme Court said that without Gaddy's testimony, Tony's conviction would not have occurred. The only way Tony could bring his claims of prosecutorial misconduct is through a writ of error coram nobis. There is no time limit on this petition, but due diligence requires that once Tony became aware of the hidden deal and Gaddy's perjury, Tony had to file his petition without delay, for fear of it being dismissed for lack of due diligence, which means that no more time could be used in trying to find more evidence. Also, Tony's uncovered facts can only be heard if the Arkansas Supreme Court grants Tony permission to return to the Deshae County Circuit Court. This is because under Arkansas Supreme Court case law, it states that
when a judgment has been affirmed by this court, no application for the writ of error coram nobis may be made to the trial court without permission to make such application has been given by this court.
in 1998, Tony filed a pro se petition into the Arkansas Supreme Court for leave to proceed in the Circuit Court with a petition for a writ of error coram nobis. As grounds for relief, Tony claimed that the state wrongfully concealed from Tony and the jury the existence of a plea bargain promised to Gaddy, that the state knowingly allowed Gaddy to perjure herself by denying the promised plea agreement, and that the state misrepresented to the jury the extent of the use immunity granted to Gaddy in return for her testimony. Tony's petition in the Arkansas Supreme Court is denied to return to the Deshae County Circuit Court to correct his unconstitutionally obtained conviction. In denying Tony's request, the Arkansas Supreme Court wrote,
Petitioner has not demonstrated that there was some fact extrinsic to the record which could not have been known at trial, which would warrant issuance of a writ of error coram nobis. The trial record reflects that petitioner's attorney at trial questioned Gaddy about inducements to testify which were granted to her by the state, and the attorney had Gaddy read aloud to the jury the order granting immunity to her. There can be no doubt that petitioner's trial counsel was aware that Gaddy's testimony was to some degree induced by her desire to cooperate with the state to receive certain advantages. Petitioner falls short of establishing in this petition that there was a hidden plea bargain agreement between Gaddy and the state. But even if such an agreement existed, he has failed to show that there was actual prejudice to him sufficient to constitute a fundamental error which calls into question the outcome of the trial. Before a writ of error coram nobis may issue, it must appear that the facts as alleged as grounds for its issuance are such as would have precluded the entry of the judgment had they been available at trial, not that such facts might have produced a different result. Petitioner has not made a showing of.
there are a number of flaws in the Arkansas Supreme Court ruling. The court abused its procedural position as jurisdictional gatekeepers for a writ of error coram nobis. Their decision involved an unreasonable application of clearly established law as determined by the United States Supreme Court, and was based on an unreasonable determination of the facts in light of the evidence presented. Not being deterred by this erroneous ruling of the court, Tony and Jean continue to seek evidence or information that will help prove Tony's innocence. Jean finally located Gaddy one day in January of 2003 after a long, hard search. Jean found Gaddy in Colorado and went to talk to her. In an affidavit, Gaddy wrote,
"While being detained and awaiting trial in Arkansas, I retracted my confession given to officers Grimes and Davidson and told several Arkansas officers on several occasions that the events I described in my confession were not true. As the prosecutor was preparing to present its case at trial against Thrash, I had refused to give a videotape deposition restating my confession given to officers Grimes and Davidson or to testify at Thrash's trial. A few days later, the prosecutor, Sam Pope, offered that he would allow me to plead to a lesser charge and a lesser sentence if I would go ahead and give him this videotape deposition restating my confession, as well testify at Thrash's trial. I requested my attorney Gibson meet with the prosecutor to discuss what the terms he had in mind and then decide if we could agree to it. After talking with the prosecutor about this, my attorney told me that the prosecutor said he was willing to the agreement, but the prosecutor just couldn't put it in writing for the jury or the defense to know or become aware of and use against us at Thrash's trial. That the prosecutor wanted us to keep this quiet. When I testified at Thrash's trial, I knew that I was not going to trial on a charge of capital murder. I knew that I would not go to trial at all. I knew that I would get 20 years on a reduced charge. I knew that the prosecutor would help me, but did not want this help known in the Thrash trial. Shortly after the Thrash trial and his conviction, the prosecutor fulfilled our agreement, asking the court for a lesser charge and sentence reduction to 20 years.
Gaddy admits in her affidavit that the rewards given for her testimony against Tony, the charge reduction, the 20-year sentence recommended by the prosecutor and accepted by the court during her plea and sentencing hearing, were the result of a hidden agreement between herself and Sam Pope. Gaddy admits she knew she was committing perjury by following Pope's order to keep their agreement hidden. Here is another hidden fact, unknown to Tony, that surfaced in Gaddy's affidavit. Gaddy said,
"While being detained and awaiting trial in Arkansas, I retracted my confession given to officers Grimes and Davidson and told several Arkansas officers on several occasions that the events I described in my confession were not true."
Meaning that Tony did not commit this crime. Yes, Tony knew that he did not kill Gil, but Tony did not know that prior to his trial, Gaddy was telling people that her confession was not true and that Tony was not involved in this crime. The state withheld impeaching evidence and knowingly allowed Gaddy to testify falsely at trial. Having Gaddy's affidavit in hand, this provided Tony with new evidence, which proves that the prosecutor withheld impeachment evidence from the defense and allowed Gaddy to lie at trial. Prosecutor Pope failed in his duty to respond truthfully to Tony's lawyer requests for disclosure of any pretrial statements made by Gaddy that could negate Tony's guilt or reduce his punishment. Glover's motion for discovery clearly requested this information from Sam Pope.
Prosecuting attorney shall disclose to defense counsel any material or information within his knowledge, possession, or control, or in the hands of any law enforcement agency that could negate the guilt of the defendant of the offense.
Sam Pope denied knowledge of Gaddy telling him that Anthony Thrash was not with her during this crime. Pope answered in response to Glover's motion.
The state is not aware of any material or information which would tend to negate the guilt of the defendant or reduce the punishment therefore.
Based on Pope denying Gaddy's pretrial statements, Tony once again seeks justice. Gaddy's affidavit represented a new form of evidence not available to Tony when he filed his first writ of error coram nobis in the Arkansas Supreme Court to reinvest jurisdiction. Gaddy's affidavit helped to show Tony's claims raised in 1998 to be true. In 2003, using Gaddy's affidavit as additional evidence, Tony filed a second motion in the Arkansas Supreme Court, claiming that the prosecutor deliberately withheld critical evidence that would have completely exonerated him, and that the prosecutor told Gaddy to commit perjury. In denying Tony's second motion, which included Gaddy's affidavit, the court basically relied on the same rationale used to deny Tony's first motion.
Gaddy avers that she was offered a plea bargain that would permit her to plead to a lesser charge, and that she was told to keep quiet about the plea bargain so that the defense would not become aware of it. The affidavit, however, does not constitute sufficient cause to reinvest jurisdiction in the trial court. Even if Gaddy's statement could be considered a recantation of Gaddy's confession, we have held that remedy by means of coram nobis cannot be invoked solely on the ground that a material witness testified falsely at trial concerning a material issue of the case, or withheld facts that might might have been material. Larimore, supra. Petitioner has not demonstrated that the prosecutor withheld material evidence. The trial record reflects that petitioner's attorney at trial questioned Gaddy about inducements to testify, which were granted to her by the state, and the attorney had Gaddy read aloud to the jury the order granting immunity to her. There can be no doubt that petitioner's trial counsel was aware that Gaddy's testimony was to some degree induced by her desire to cooperate with the prosecution to receive certain advantage. Petitioner falls short of establishing in this petition that there was a hidden plea bargain agreement between Gaddy and the state. But even if such an agreement existed, he has failed to show that there was actual prejudice to the defense sufficient to constitute a fundamental error which calls into question the outcome of the trial. Before a writ of error coram nobis may issue, it must appear that the facts as alleged as grounds for its issuance are such as would have precluded the entry of the judgment had they been available at trial. Not that such fact might have produced a different result. Larimore, supra. Petitioner has not made a showing of fundamental error.
This second ruling denying Tony's motion to reinvest the trial court with jurisdiction presents the same errors made by the Arkansas Supreme Court in its first ruling against Tony. How did the court's decision involve an unreasonable application of clearly established law by the United States Supreme Court? Involve an unreasonable determination of the facts in light of the evidence presented? We must understand how hiding evidence with lies and deception by the prosecutor affected Tony's ability to fully defend himself and the effect it had on the jury's deliberation in finding Tony guilty. Prosecuting attorneys are duty-bound to disclose evidence favorable to the accused as a matter of constitutional due process.
No person shall be deprived of life, liberty, or property without due process of law, nor shall any state deprive any person of life, liberty, or property without due process of law. The prosecuting attorney shall promptly, upon discovering the matter, disclose to defense counsel any material or information within his knowledge, possession, or control, which tends to negate the guilt of the defendant as to the offense charged, or would tend to reduce the punishment thereof.
This duty to disclose is designed to afford the defendant a full opportunity to contest the prosecution's case. As far back as 1935, in the case of Mooney v. Holohan, the United States Supreme Court addressed these issues. The Mooney Court wrote,
"In safeguarding the liberty of the citizen against deprivation through the actions of the state embodies the fundamental conception of justice, which lie at the base of our civil and political institutions. It is a requirement that cannot be deemed to be satisfied by mere notice and hearing. If a state has contrived a conviction through the pretense of a trial, which in truth is but used as a means of depriving a defendant of liberty through a deliberate deception of court and jury by the presentation of testimony known to be perjured, such as a contrivance by a state to procure the conviction and imprisonment of a defendant, as is inconsistent with the rudimentary demand of justice, as it is the obtaining of a like result by intimidation."
In Napier v. Illinois, the United States Supreme Court dealt with a case exactly like Tony's. In this case, Hammer, a key witness for the prosecution, made a deal with the prosecutor for his testimony. This was not disclosed to the defense prior to the trial, thus not available to the defense as a basis for impeachment. Co-defendant Hammer denied that he had been promised anything for his trial testimony against Napier. Even though Hammer had already been tried and sentenced, the Supreme Court has held that when a Napier violation occurs, a new trial under the Due Process Clause should occur. Unlike the Arkansas Supreme Court's assessment, the United States Supreme Court has said,
"The principle that a state may not knowingly use false evidence, including false testimony, to obtain a tainted conviction, implicit in any concept of ordered liberty, does not cease to apply merely because the false testimony goes only to the credibility of the witness. The jury's estimate of the truthfulness and reliability of the given witness may well be determinative of guilt or innocence. It is upon such subtle factors as the possible interest of the witness in testifying falsely that if a defendant, his life or liberty may depend. It is of no consequence that the falsehood bore upon the witness credibility rather than directly upon the defendant's guilt. A lie is a lie, no matter what its subject, and if it is in any way relevant to the case, the district attorney has a responsibility and duty to correct what he knows to be false and elicit the truth. That the district attorney's silence was not the result of guile or a desire to prejudice matters, it matters little, for its impact was the same, preventing as it did a trial that could in any real sense be termed fair."
These rulings by the United States Supreme Court show the harm done to both society and the defendant when convictions are obtained through the known use of perjured testimony by the state. The Arkansas Supreme Court rulings Tony received do not match the United States Supreme Court standard. The Arkansas Supreme Court saw Tony's claim as insignificant, that the state violated his right to a fair trial by failing to disclose Getty's pretrial exonerating statements. But this is how the United States Supreme Court has seen this type of claim since the 1963 case of Brady v. Maryland.
We now hold that the suppression by the prosecution of evidence favorable to the accused upon request violates due process where the evidence is material either to the guilt or to the punishment, irrespective of the good faith or bad faith of the prosecutor. The principle of Mooney is not punishment of society for misdeeds of a prosecutor, but avoidance of an unfair trial to the accused. Society wins not only when the guilty are convicted, but when criminal trials are fair. Our system of administration of justice suffers when any accused is treated unfairly. A prosecution that withholds evidence on demand of an accused which is made available would tend to exculpate him or reduce the penalty, helps shape a trial that bears heavily on the defendant. That casts the prosecutor in the role of an architect of a proceeding that does not comport with the standards of justice, even though, as in the present case, his action is not the result of guile.
There are literally hundreds of cases showing both federal and state courts that uphold and follow the authority of the U.S. Supreme Court. Finding such actions on the part of prosecutors, as in Tony's case, violates a defendant's constitutional right to a fair trial. Tony and Jean recognize that by law, Tony is entitled to a new trial. Receiving these denials from the Arkansas Supreme Court could only mean they needed stronger proof to show the court their allegations are true. So in August of 2003, Jean went back to Getty for a more detailed description of the events that took place while she was awaiting trial in 1985. The facts cannot be more plainly expressed, as Getty states them in her affidavit, showing that prior to Tony's trial, she told Pope and other officers that Tony did not commit this crime.
I told several Arkansas officers on several occasions that the events I described in my confession were not true. I specifically told May and Edward Sewell, Arkansas officers, while on a number of weekend visits to their home after church, that Tony Thrash was not with me during this crime. I also know that I discussed the fact that Tony Thrash was not with me, nor committed this crime with other Arkansas officers, a female dispatcher and a male officer named Kim and Connie, a female officer. The weekend that Prosecutor Pope came for a videotape statement along with Attorney Gibson, I told them it was all a lie, meaning that my confession was not true and that Tony Thrash was not with me. I remember telling Prosecutor Pope that this is my life and my decision and I may want to take the death penalty. I was unwilling to continue implicating Tony Thrash in this crime and told Attorney Gibson to meet with the prosecutor. Attorney Gibson told me that it is not me the state wants, but Tony Thrash.
Getty refused to testify at Tony's trial until Pope made the deal too sweet to refuse.
I continued to be unwilling to implicate Thrash in this crime. It was during this period of time that my attorney told me that Prosecutor Pope was willing to make a verbal agreement with me on a lesser charge, lesser sentence if I would not let the defense or the jury become aware of our agreement, as well as testify against Thrash at trial. Nothing should be on paper so that I could go before a jury and say I was not offered anything. It was my understanding that Prosecutor Pope included as a part of this agreement that during the Thrash's trial I was to explicitly deny that any agreement of any kind had been made or offered to me in return for my testimony. During Tony's trial, I knew that I would not be going to trial on a charge of capital murder, and I also knew that I would not go to trial at all, knowing that my testimony must enable the state to get a conviction on Tony Thrash. The prosecutor was told that Tony Thrash was not with me in this crime, and I believe that if I backed out from my testifying against Tony Thrash, the state would have the videotape to implicate me as an insurance policy to testify against Thrash. I understood that this was to ensure the prosecutor that my confession would remain consistent. No one at any time would listen to my recantation before Thrash's trial.
Early January 2004, Jean found one of the officers Getty named in her affidavit. Jean obtained an affidavit from Connie Nations. Ms. Nations is one of the persons that Getty spoke of in her affidavit as being a female dispatcher, Connie, whom Getty told that Tony was not with her nor committed this crime. Ms. Nations' affidavit says,
"My name is Connie Nations. I'm retired. In 1985, at the time, Deidre Grady and Tony Thrash were in custody and waiting trial for the murder of Tommy Gill. I was employed as a dispatcher in the Arkansas City Jail. While Gaddy was being detained at the Arkansas City Jail, I can say I never remember Gaddy saying that Thrash did it, with my impression being that Thrash was not in this crime, given Gaddy's talk of it during the 1985 period of time.
Dispatcher Nation's acknowledgement of Gaddy's pretrial statement that Tony was not in this crime verifies factual truths in Gaddy's affidavit, proof of Tony's allegation concerning the misconduct on Prosecutor Pope's part to be true. The Arkansas Supreme Court said that none of these issues had an effect on the outcome of Tony's trial. Having such evidence as revealed in these affidavits, this aroused Jean's curiosity, which led her to talk with one of the jury members that heard Tony's case. Mr. Hampton sat on the jury in Tony's trial.
I would not have voted guilty had I known these things at trial.
While the court ruled that Tony's evidence would not have changed the jury's verdict, Juror Hampton's affidavit, a person who sat and heard the prosecution's case against Tony, undoubtedly contradicts the court's opinion.
In reading these court records and affidavit altogether as a whole, I would not have voted guilty as a juror in Anthony Thrash trial. Had I known these things at trial as a juror, I was not given the truth about Deidre Gaddy's immunity and the promises made to her by the prosecutor for her testimony against Anthony Thrash. Had Anthony Thrash attorney taken a statement from Deidre Gaddy prior to trial, she may have told of his not being a part of this crime, as she says in her affidavit and is in Miss Nation's affidavit, and been able to tell the jury this definitely hurt Anthony Thrash case.
In 2005, Tony was in the process of filing for executive clemency and wanted to use Juror Hampton's affidavit as a part of the evidence presented in his clemency application. Before Tony had a chance to provide the board with a copy of Juror Hampton's affidavit, the Board of Parole voted that Tony's application was without merit. Subsequently, Governor Mike Huckabee denied Tony's application as well. Favor finally came Tony's way when in 2007 Tony submitted a request to the Arkansas Board of Parole to reconsider his case, which this time included a copy of Juror Hampton's affidavit. Based on the content of Juror Hampton's affidavit, the board elected to conduct a hearing in order to properly evaluate the substance of the evidence attached to Tony's renewed application. Executive clemency was recommended by the Board of Parole with merit, and Tony's sentence to be commuted. Both Deidre Gaddy and Juror Hampton attended Tony's clemency hearing in person to confirm what was said by them in their affidavit. Gaddy and Juror Hampton came to speak on Tony's behalf. Tony and Jean couldn't help but be excited to receive such a worthy and deserved recommendation from a board that wasn't afraid to act on its ethical and moral conscience. At the same time, they were very aware that it was the governor's duty to make the final decision, and even though the parole board found Tony's evidence to show a strong case of injustice warranting a sentence commutation, it was still necessary to convince the governor that Tony's case is truly worthy of having the board's recommendation granted. Renowned journalist and author Maura Leverett wrote a cover story published in the Arkansas Times regarding Tony, his conviction for murder, and appeal for clemency. In preparing to write this article, Miss Leverett conducted her own independent investigation on Tony's case. It was Miss Leverett who found the copies of the 1980 witness statements. These are the 1980 witness statements not seen until decades later and shown at the beginning of this presentation. Miss Leverett asked Jean and Tony if they had seen them. No, they had not. There was other pertinent evidence Miss Leverett had found during her investigation, which confirmed Sam Pope's misconduct against Tony. Jean scheduled a meeting with the governor's office in order for Miss Leverett to present her newly uncovered evidence to the governor, but the governor's office refused to allow Miss Leverett an opportunity to attend this meeting. Thus, this evidence acquired by Miss Leverett was never presented to the governor. In 2009, Governor Mike Beebe denied Tony's application. Surprisingly, out of everyone involved in seeking justice for Tony, it was Juror Hampton that ended up being the most devastated and lost by receiving the governor's denial. Mr. Hampton felt that the system had not only let Tony down once, again, it failed him as well. Mr. Hampton expressed being under emotional strain since learning the true facts of Tony's case and seeing how he had been used by Sam Pope to put an innocent man in prison for the rest of his natural life. Juror Hampton was not just asking the governor to have mercy on Tony. He was asking the highest seat in the state to correct a wrong that the state itself actively consummated. Juror Hampton was not just asking to restore Tony's liberty, but to also allow him to resolve the hurt and the guilt that he must endure from the role Pope deceived him into playing, which created the wrong that Tony suffers. Juror Hampton was unable to comprehend how a governor who has the complete authority to correct such atrocities did not. How could our state's leader appear to be so unattached to the pain, bewilderment, and guilt Juror Hampton had to live with? Juror Hampton's only fault was that of being selected as one of 12 to perform his civic duty and having the misfortune of being paired with a prosecutor whose only duty, it seems, was to win at all costs. These words in Juror Hampton's affidavit express what he felt about being deceived.
I did not see Anthony Thrash as a person who could kill another person, and voted not to have him receive the death penalty after voting him guilty. There was doubt in my mind in 1985, but Deidre Gaddy, as an accomplice, testified against him, and I was led to believe at her own expense. The evidence against Anthony Thrash did not make sense to me at times, and was not strong evidence, but the lead to believe unprotected testimony of Deidre Gaddy gave reason to vote guilty, because she had everything to lose. The plea and sentencing hearing of Deidre Gaddy with the prosecutor that took place only days after Anthony Thrash was convicted, along with the misrepresentation of the immunity granted by the prosecutor, and Deidre Gaddy affidavit and Miss Nation affidavit convinced me that I was not given the truth as a juror to vote on Anthony Thrash guilt. Please grant Anthony Thrash clemency and commute his sentence. This was not a fair trial or a just one. I should know because I was there and know what and how I was given information as a member of the jury.
Out of every judge, commissioner, and governor that reviewed Tony's case, were the parole board members who recommended Tony's sentence to be commuted the only people to believe Tony's claims of injustice to be true? Or were they simply the only people who care about correcting an injustice? Or should justice only come to a select few and not to us all?